Good afternoon, everyone. I'm Harsh Amrit, and I would be serving as court in charge for this room. I'm accompanied by Ms. Pratiti Zarika, who is the court clerk. I, on the behalf of the MOOT Court Committee, Naluja, would like to welcome you all to the final rounds of the third edition of the Gurjeet Singh Memorial National MOOT Court Competition. With a head start of 22 learned teams, we are left with two learned teams. We are left with two well-deserving teams for the grand finale today. We have Team TC1 as petitioners and Team TC10 as respondents. The round will be of total of 70 minutes, with each side getting 35 minutes each. The court clerk will let the speakers know when they have 10 minutes, 5 minutes, and 2 minutes left. The rounds of today will be presided over by Honorable Mr. Justice N. Kotishwar Singh, Honorable Mrs. Justice Rumi Kumari Fukan, and Honorable Mr. Justice Manish Chaudhary. Honorable Justice N. Kotishwar Singh is the former Chancellor of this university and the senior most judge of the Guwahati High Court. Sir has also briefly practiced in the Supreme Court, Central Administrative Tribunal, Guwahati, and the subordinate courts in Manipur, then Common High Court of Assam, Nagaland, Meghalaya, Manipur, and Tripura, before being elevated to the High Court. Honorable Justice Rumi Kumari Fukan worked as a district and sessions judge of Dibrugarh and was elevated as additional judge and is currently serving as permanent judge at the Guwahati High Court. Honorable Justice Manish Chaudhary, sir, was designated as senior advocate by the Guwahati High Court then elevated as additional judge and is currently serving as permanent judge at the Guwahati High Court. I would like to wish all the best to the teams and hope they enjoy pleading before this bench. And with the permission of the honorable judges, I would like to invite Speaker 1 from the petitioners to address the bench.
Yes, you may proceed.
Am I audible? Hello?
Yes, we can hear you.
Your Lordship, kindly allow for a minute. There's a technical error. Please kindly allow for a minute. Hello.
Yes.
Greetings of the day to the bench. The council seeks permission to address the bench collectively as your lordships and individually as your lordship.
Yes, we can.
This is to humbly submit that the council shall present the case and assist your lordships with the issue number 1 and issue number 4, while the co-counsel shall assist the Honorable Court with issue number 2 and issue number 3. The first counsel shall present the council's case in first 20 minutes, followed by the second counsel presenting the council's case in next 13 minutes. If your lordships have adequately been assisted with the chronology of the arguments, the council seeks permission to assist the Honorable Court with the facts of the impugned case.
Yes, proceed.
Your lordships, the petitioners in the instant case are two talented young engineers who've graduated from the most prestigious universities of the world and have been awarded scholarships by the government of this very country. Your lordships, having worked in some of the largest multinational companies of the world, these young talented individuals one day decided to relocate back to Indra. However, a dark fate seemed to have been let loose on them, wherein on 20th February 2022, they were arrested by a huge battery of police that claims that they have discovered secret basement-like structures beneath their premises filled with arms and ammunitions. Your Honors, it is further submitted for your kind consideration that in this instant case, two young boys have been attributed to have supplied arms to extremists against the Indian nation and are also alleged to have used the dark web, hold large amount of unaccounted currency and cryptocurrency, and have connections with anti-national elements. Your Honors, it is even on the very next day of being arrested, the petitioners were slapped with a notice under Section 50 of the PMLA issued by the ED. Further, their demands have constantly been increased, and there have been several extensions of their judicial custody. Therefore, having failed to receive justice, the petitioners separately applied for a grant bail in the FIR registered by the police in Faizabad. However, no, there doesn't seem to be any justice coming their way. However, it is your lordships, considering the abject situation of hundreds of accused like the petitioners who languish in jails in pre-trial situation, like the way petitioners have been languishing in jails for last 80 years, the petitioners decided to challenge the wires of the most draconian laws of this country before this honorable court. Your honors, your lordships, if you have adequately been assisted with the facts of the case, the council seeks permission to proceed with the submissions of the first issue at hand.
Yes.
Much obliged, your lordship. Your lordship, the first issue deals with the first issue contends that the writ petition filed by the petitioners is maintainable under Article 32 of the Constitution of India. Your honors, the Constitution of India, as has been made by the great constitution makers of this country, envisages freedom for all the individuals. However, this safeguard of to safeguard this very spirit of the Constitution of India, the petition lies before you, wherein it is contended that the various provisions of various laws that have been contended both from PMLA and UAPA are violative of the fundamental rights of the petitioners and many other individuals who've been languishing in jails for multiple years, many decades, because of the draconian provisions as are provided by this provision. Your honors, furthermore, it is also submitted that in the historic judgment of People's Union for Democratic Rights versus Union of India in the year 1982, wherein this Honorable Supreme Court of India was addressing an issue as grave as that of child labor, in the paragraph 10, the court held that in the instances of public injury or wrong, if caused by any act or omission of the state, every individual will be assumed to have the locus standi to approach the court. Your honors, similarly, in the case of Purtapur versus Kane Commissioner, the court not only held this, but also held that it is essential for any petition to be any petition to have the spirit of public interest. Your honors, your lordships, in this instant case, this petition not only intends to aid these two abjectly placed individuals, but also intends to serve those hundreds of people languishing in jail, and therefore, due to the presence of this nature, of element of public interest, the council also furthermore pleads that this writ petition is maintainable as a public interest litigation. Your honors, in the case of Dattaraj Nathuji, versus state of Maharashtra, in the state of Maharashtra, the Honorable Justice Arjit Pasayat, writing for the bench, held that in the paragraph 4 held that a person acting bona fide and having sufficient interest in safeguarding public interest reaches the court, wherein under Article 32, then it will be held that the person has the requisite locus standi. Therefore, having advanced these arguments and having presented before you, your kind lordships, that the petitioners have not only reached the special courts under the UAPA and the PMLA, but also have have applied for bail before the Honorable High Court of Allahabad, the High Court of Judicature in the instant case, and have found no respite in either of the cases. Having exhausted all of their alternatives, the petitioners are here with a requisite locus standi, presenting a case of absolute public interest, opposing a law, the wires of a law that has been cause of plight of hundreds of people. And therefore, it is humbly pleaded before your kind selves that this writ petition is maintainable before this honorable court. Your lordships, if you have adequately been assisted to your satisfaction with the issue number 1, the council seeks your permission to proceed to the second issue, that is the issue number 4.
Yes, please.
Much obliged, your lordship. Your lordship, as far as the issue number 4 of the instant situation is concerned, it is humbly submitted that the reversal of burden of proof that is provided by the UAP under the section 43D5 of the Act is not violative of the Constitution of India. Your Honours, Article 14 of the Constitution of India enshrines the right to be treated equally by the makers of this Constitution. The Honourable Supreme Court in the case of M. Nagaraj versus Union of India, wherein it was referring to a similar case of classification, although of social importance, in its judgment in the paragraph 78 had held that had given a rather unique dimension to this article, wherein the court had held that any concept of equality allows differential treatment. It is on the basis of this judgment of the Honorable Supreme Court of India, the Council humbly submits before your kind lords that the provision suffers from a manifest arbitrariness. The classification that is provided by the provision is arbitrary, is not founded on intelligible differentia, and the provision of reasonable grounds, as has been provided by the provision, is ambiguous. Your Honours, proceeding with the first prong of the argument, the provision suffers from manifest arbitrariness. Your Honours, your lordships, as has already been mentioned before you, that a law provides classification of any sort has to meet the requisites of Article 14. The Indian Supreme Court, in the case of Bhagat Ram versus State of Himachal Pradesh, wherein suspension of an individual was done arbitrarily on the basis of of an arbitrary law, the Supreme Court of India had held that legislation which is excessive and disproportionate in nature will be manifestly arbitrary, and therefore the moment a legislation like that is enacted or is passed, the subjects to the legislation have the bona fide intent and have the requisite locus standi to approach the court. Given this degree of manifest arbitrariness, your Honours, it is humbly submitted before your kind selves that the impugned provisions is manifest arbitrary. Your Honours, to only bolster this point of this submission regarding manifest arbitrariness of the provision, the Council further brings in two new facets, two new faces to this submission, Your Honours. The first facet is that the classification is not founded on intelligible differentia. Your Honours, the Indian Supreme Court, in the historic judgment of the state of West Bengal versus Anwar Ali Sarkar, in the paragraph number 47, while adjudicating on an issue of special courts, had held that all litigants similarly situated are entitled to avail themselves of the similar procedural rights for relief and defense with the same protection without any discrimination, and therefore a law that mars this principle should be considered to be not based on intelligible differentia. Your Honours, in the instant situation, if one looks at the provision of the section 43D5 of the UAPA, it is very clear that it imposes an additional burden of proof on the individual accused, and therefore it not only creates a classification which is unjust, but it appears to be deviating from the whole idea of intelligible differentia. Your Honours, if your kind selves have adequately been assisted with the first sub-issue of the instant sub-issue, the Council shall proceed to the next sub-issue that provides that the expression reasonable ground is ambiguous.
Are you aware of any decision of the Honorable Supreme Court where this issue of the constitutionality of such provisions of presumption, this reverse burden, has been upheld in any other statute? Are you aware of any decision of the Honorable Supreme Court where this issue of this reverse burden, the constitutionality of it has been challenged and it has been upheld or rejected? Are you aware of any decision of the Honorable Supreme Court?
Indeed, Your Honours, indeed, Your Lordship, yes, I'm aware. However, it is not related to the UAPA, but it is related to another statute where, in the decision of K. Veeraswamy, the court held that given the seriousness of certain offences, this kind of apparently arbitrary provisions can be allowed. So, Your Honours, in the K. Veeraswamy versus Union of India, the constitutionality of Section 5(1)(e) and Section 5(3) of the Prevention of Corruptions Act was challenged, which provided for a similar kind of provision, Your Honours, Your Lordship.
Okay. Okay, you may proceed further. You have to unmute your mic.
Apologies,
Yes.
apologies, Your Lordship.
Yes.
Your Lordship, with your permission, the Council now proceeds to contend and humbly submits before your kind selves that the expression reasonable ground, as has been provided by this provision, is very highly ambiguous. Your Honours, the section 43D5 provides that an accused cannot be allowed bail until the court has reasonable grounds for believing that the accusation against such person is prima facie true. However, this reasonable ground, or this whole idea of prima facie that is incumbent on this provision of reasonable ground, is very subjective. To prove the same, the Council wants to illustrate here the case of Narcotics Control Bureau versus Dilip Prahlad Namade, where in the year 2004, the Honorable Supreme Court, in its judgment in the paragraph number 10, while explaining the concept of reasonable grounds, held that reasonable ground is something much more than prima facie grounds. However, in a recent judgment related to a UAPA case, in the Najib's case, the Honorable Supreme Court held that in that reasonable grounds refers to only prima facie proving of the fact as per the section 43D or 5 of the impugned provision. Your Honours, on the basis of this anomaly that exists in the interpretations at various levels, there have been instances of severe you can say unjustified denials of bails of certain individuals. Your Honours, it is due to this ambiguity that exists in the definition of reasonable ground. Many individuals have been denied bails on the High Court levels and have been allowed bails by the Supreme Court. Your lordships, your kind lordships, as you're already aware, one such similar instance took place in the case of Natasha Narwal versus State in the case of NCT of Delhi, where a young girl was jailed under UAPA only for protesting against a law passed by the honorable Parliament of this country. The court dismissed the court granted bail to the individual accused in the instant case against the Honorable Delhi High Court's decision to not grant bail. Your Honours, your Lordship, this is just another one instance of where this anomaly has led to unnecessary and unjustified confinement of these individuals. Your Honours, now the Council also submits that the provision can cause curtailment of the liberties of innocent individuals. Your Honours, arrest in terms of legal perspective might seem like a mere decision if a person has to be confined or not, but the Honorable Supreme Court in the case of Siddharam Satlingappa Mahatre versus State of Maharashtra has given a humanitarian aspect to this concept of arrest in paragraph 97, basing it on the realities of Indian society, where the court has held that nobody in Indian society, or majority of the Indian society, fails to differentiate between arrest and a pre-trial arrest, and therefore the court held that there is immense amount of ignominy, humiliation and disgrace that is attached to a person who is preventively arrested. It is on this ground, your Honours, your Lordships, it is pertinent for this court to look at the record of pending cases that continues to exist under the UAPA registered cases. Your Lordship, it is humbly submitted that in the year 2014, 1,857 cases had not been tried, which rose by 37% in 1 year to the year 2015, when 2,549 cases were left untried. By the year 2020, this number has more than doubled, or you can say there is a 250 times increase, wherein 4,021 untried cases only till 2021, 2 years before today, as provided by the NCRB, were not tried. And most of these people, because of the very harsh provision of the 43D5, continue to languish in jail. Your Honours, your Lordships, it is considering draconian provisions like these in the case of Shaheen Welfare Association versus Union of India and others, which was essentially a public interest litigation against a similar provision. The Honorable Supreme Court in its judgment in the paragraph 10 had held that stringent bail conditions, for example, in this case, the one provided by the section 43D3, can be justified in special criminal legislation, could only be justified if a swift trial took place. Now, your Lordships, if one looks back at the pending cases, and in fact in the instant case where two brilliant minds of this country have been languishing in 80 jails, and they must be not the only ones, there must be hundreds of people who must be languishing in jails. It is for this court to not only take a legal cognizance but also a humanitarian cognizance that this honorable kind court has always done, to ensure that the safeguard of these individuals languishing in jails for no reason of no mistake, for a legal deal, for a procedural delay, is stopped. Your Honours, Your lordships, if your kind selves have been assisted adequately on this issue, the council seeks permission to proceed to the next issue that provides that humbly submits that the law does not follow the procedure established by law.
Yes, yes, you may
Much,
proceed.
much obliged, your lordships. Your lordships, in the case of Bashir versus State of Uttar Pradesh, while delineating on a similar provision wherein a confinement had occurred in the paragraph, in the paragraph, apologies, in the paragraph 10 of the judgment, the court had held that a person, if is deprived of his life or liberty, it cannot be done unless the procedure established by law. At this juncture, it is essential to place reliance on what is happening, what is provided by this provision. Sir, your lordships, your provision provides that the reversal of burden of proof minimizes the work on of the prosecution to the substantial degree, and if evidence is shown to be prima facie true, then whole of the burden shifts to the accused, and it is highly improbable for the accused to prove the absence of mens rea. Your honors, it is on this ground it is humbly submitted that the procedure established by law is contravened by these provisions. Your honors, furthermore, the council also pleads that this provision also abridges the right of free trial. Your honors, your lordships, in the case of Motilal Saraf versus State of Jammu and Kashmir in the year 2007, wherein a non-Jammu and Kashmiri was jailed in Jammu and Kashmir in the name of corruption, the court had held that just because the person is an outsider, it doesn't mean that the person ceases to have the right to life and right to liberty, which is one of whose essential components is right to free trial. The Honorable Supreme Court, in fact, in the case of Siddharam Satlingappa Mahatre versus State of Maharashtra, where there were shootings between two political groups of two different parties in the ruling in the state of Maharashtra, had observed that the presumption of innocence was a part and parcel of the free trial, and since free trial is a fundamental right, therefore right to be presumed innocent is an inalienable component of the right, and therefore should also be considered and should also qualify as a fundamental right. Your honors, your lordships, therefore section 43d5 of the UAPA, passing the burden of proof on the accused, violates the mandate of the court and contravenes the accused's right to be presumed until proven guilty. Your honors, secondly and lastly, the council here submits to your kind selves that in the case of Siddharam Satlingappa and versus State of Maharashtra in the year 2011, the courts provided the presumption of innocence can be effective by favoring bails. Furthermore, similar idea was upheld by the Honorable High Court of Punjab and Haryana in the case of Ankush Kumar versus State of Punjab, where the court held that any provision that directly abridges this presumption of providing the bail goes dramatically against the whole principle of bail, and therefore the mandatory requirement for the accused to prove himself innocent minimizes the work of prosecution to a substantial degree. And if the evidence by the prosecution is shown to be prima facie true, then it is completely incumbent on the accused to prove the absence of guilt, which is completely difficult in a situation where his bail is opposed by agencies as sophisticated as the NIA and the most learned lawyers of the country. Your honors, it is on these grounds that the counsel for the petitioner humbly, with humility, submits before your kind selves that the provision be struck down, and it has been an absolute honor. The council seeks your permission to make way for the second counsel for the petitioner to present the council's submissions.
Yes.
Much obliged.
Yes, you may proceed. Yes.
Warm greetings to the bench.
Yes.
May it please the Honorable Court. This is the second counsel appearing on behalf of the petitioners in the present case. Your Lordships, the first issue before this court is whether the twin conditions under the Unlawful Activities Prevention Act of 1967 and the Prevention of Money Laundering Act 2002 are ultra-vires. Your Lordships, in the present case, the petitioners have been denied bail on the grounds of the twin conditions under Section 43D, subclause 5 of the UAPA Act and Section 45 of the Prevention of Money Laundering Act. And this has been challenged for these twin conditions for these twin conditions are violative of the very fundamental rights guaranteed under the Constitution of India. Your Lordship, since a greater part of this issue dealing with the validity under Article 14 of the Constitution has been deliberated upon by Council 1, the second counsel would now proceed to the second leg of this argument, which contends that these provisions are violative of Article 21 of the Constitution. Your Lordships, it is humbly submitted that Article 21 of the Constitution provides that every person has a right to life and personal liberty, except according to the procedure established by law. And relying upon the decision of the Honorable Supreme Court of India in the case of DBM Patnaik versus State of Andhra Pradesh, when a convict is in prison, he cannot enjoy all the fundamental rights. However, he is still not denuded of all the fundamental rights and therefore can still claim his right to life. Your Lordships, in the case of in the latest case of Nikesh Tarachand Shah versus Union of India, under paragraphs 27 and 38 of the judgment, the Supreme Court of India had held that manifestly arbitrary, discriminatory, and unjust results would arise on the application of section 45 of PMLA and would directly violate articles 14 and 21 in so much as the procedure for bail would become harsh, burdensome, wrongful, and discriminatory. Hence, section 45 of the PMLA is liable to be struck down as being manifestly arbitrary and providing a procedure which is not fair or just and would thus violate both articles 14 and 21 of the Constitution. Hence, it is humbly submitted before your Lordships that the twin provisions are creating an overgenerous infusion of constraints and restrictions on bail, making the provisions unjust, unfair, and unreasonable, and hence are liable to be struck down. Since there are no safeguards in the favor of the accused, this renders the entire process to be disproportionate and arbitrary. If your Lordships are satisfied with the...
Yes. Proceed.
Much obliged, your Lordship. Your Lordships, the second issue at hand is whether Section 50 of PMLA is violative of the Indian Evidence Act. Your Lordships, it is most humbly submitted that Section 25 and 26 have been laid down in the Evidence Act to safeguard the under trials and to prevent any abuse of machinery, and it is contended that Section 53 of PMLA, which allows the ED officers to summon anybody to give evidence during the course of investigation and bound such persons to state truth in his statement and to sign that statement. And Section 50 subclause 4, making that summon a judicial proceeding, is violative of Sections 25 and 26 of the Evidence Act, read in consonance with Article 20, subclause 3 of the Constitution. Your Lordships, the Constitution provides that Your Lordships, the Constitution provides the fundamental right against self-incrimination under Article 20, subclause 3. And in that regard, Section 25 of the Evidence Act states that no confessions made before a police officer shall be made admissible before the court. And Section 26 states that no confessions made by any person while he is in the custody of a police officer, unless it is made in the immediate presence of a magistrate, shall be proved against that person. These sections hereby uphold the spirit of Article 23 of the Constitution. Your Lordships, it is humbly submitted that the ED officials under the Prevention of Money Laundering Act fall within the ambit of police officers, and hence the statements made before them cannot be made admissible before the court. Else it would violate Section 25 and 26 of the Evidence Act in consonance with Article 20, subclause 3 of the Constitution. Your Lordships, the Council relies on the decision of State of Punjab versus Barkat Ram, wherein, while dealing with the question of whether customs officers can be brought within the ambit of police officers, the court had held that they would not be equated to police officers because the powers conferred on the custom officers are merely for the purpose of ensuring that dutiable goods do not enter the country. This case becomes important because in paragraph 10 of this case, the Supreme Court had stated that if the purpose of the special statute is to detect and prevent a crime, and to achieve this purpose, coercive powers like arrest, remand, a search of person or property, which could expedite extracting a confession from the suspect, are given to the officers under the special statute, then such an officer would be under the ambit of police officers. And it is therefore submitted before the court that since PMLA is since the Prevention of Money Laundering Act is a penal statute that deals with the provisions of criminal offences, through effective detention and prevention of crime, it has to be considered that the Enforcement Directorate under PMLA will be considered within the ambit of police officers. Your Lordships, it is further submitted that with regards to the judicial proceedings under Section 50, subclause 4, the term judicial apologize for the inconvenience, Your Lordships. The terms judicial proceedings have not been defined in PMLA. and the only statutory definition of the same has been provided under section 2 subclause 1 of the CRPC, which states that judicial proceeding includes any proceeding in the course of which evidence is or may be legally taken on oath. It has been held that suit or a prosecution are those judicial or legal proceedings which are lodged in a court of law and not before any executive authority, even if it is a statutory one, as is what laid down in the case of Assistant Collector of Central Excise versus Ramdev Tobacco Company. Hence, it is submitted before your lordships that the statutory scheme of Prevention of Money Laundering Act, as set out under Section 50 of the Prevention of Money Laundering Act, in the absence of the safeguards provided under Article 20 subclause 3 of the Constitution, is violative of Sections 25 and 26 of the Evidence Act, because the ED officers will be considered as police officers and hence is liable to be struck down. If your lordships are satisfied with the arguments, the council will seek your permission to proceed to the prayer.
Can you tell us the corresponding provision under the CRPC to Section 25 of the Indian Evidence Act?
Your lordship, just a second, your lordship is contained under Section 162 of CRPC, which states that 161 of CRPC, that statements recorded under 161 by the police officers can only be used for contradicting the witness in course of examination of the witnesses.
And what is that bar similar to provided under Section 25 in the CRPC?
Your lordship, the council begs pardon on this issue.
Council,
Yes, sir.
you have referred to Nikesh Tarasan Sa,
Yes, sir.
where it has been declared that Section 45 of the PML
Yes.
Act
Is
is
violated.
arbitrary.
Yes, sir.
Now, at the same time, the Honorable Supreme Court of India in Nikesh Tarasan Shah has said that the perimeter provisions in the TADA, as well as the perimeter provision in the Narcotic Drugs and Psychotropic Substances Act 1985, are not arbitrary. So the provisions in TADA perhaps are perimeter to the UAPA Act.
Yes, sir.
Now, the reason why this Section 45 has been declared to be arbitrary in Nikesh Tarasan Shah, can you just highlight on that? What is the reason why this has been declared to be arbitrary?
Your lordships, in this case, while striking out these provisions, Supreme Court had held that the provisions that just a second, your lordships. Your lordships, it was stated that
judgment itself, perhaps there is a discussion.
If you have the judgment before you,
yes, your lordship.
paragraph 35.
The
Paragraph
reasons
35.
why it was passed.
Anyway, you proceed.
Yes, your lordships. Much obliged, your lordships. Your lordships, wherefore, in the light of the facts stated, issues raised, arguments, authorities cited, and arguments advanced, it is most humbly prayed before the Honorable Court that it may graciously please to adjudge and declare that issue a writ of mandamus or any other appropriate writ direction order in the nature of writ directing that the conditions imposed under Section 43D, subclause 5 of the Unlawful Activities Prevention Act, 1967, for it is violative of Articles 14 and Article 21 of the Constitution, and thus declare being unconstitutional, issue a writ of mandamus or any appropriate writ direction order in nature of a writ directing that Section 50, subclause 3 and subclause 4 of PMLA violates Article 20, Subclause 3 and Article 21 of the Constitution, read with Sections 25 and 26 of the Indian Evidence Act, and or pass any order, direction, or relief that it may deem fit in the best interest of justice, equality, and good conscience. It was an oral argument before this honorable court.
Okay, that's all. Okay, very well.
I want to ask a question. I want to. Hello. I just simply want to ask you a question. So every act has aims and objective. While enacting a piece of special legislation, legislator has always a mind to brought some stringent condition in certain acts. Perhaps in this act also there is aim and object has been described. So what is your opinion why this stringent action has been taken regarding granting bail? Have you gone through the object of the act?
Indeed, Your Lordship, the council seeks to know if the council is Your Lordship is referring to the council number 1 from the side of the petitioners.
Two. I'm asking for two.
Okay.
Two.
Yes, Your Lordship. Your Lordships, the reason behind the intent of the by referring to the initial debates on the UAPA bill, it was stated there were several concerns were raised. Even though the intention of the condition was to seek combat money for the PMLA, it was to seek major objectives were to prevent and control money laundering, to confiscate and seize the property obtained from money laundering, and to deal with any other issue connected with money laundering in India. However, Your Lordships, and for UAPA also, they wanted to combat terrorist activities to safeguard the nation. However, Your Lordships, in the initial debates on the UAPA bill, several concerns were raised and negative connotations were passed regarding the bill. It was stated that this bill would be keeping an accused in the jail without a trial, which would in turn take away an individual's freedom. And the Constitution is based on and the entire criminal justice system is based on the principle that every accused has a right to be every accused has to be presumed innocent until he has been proven guilty.
That concept is actually subject to the trial only.
Yes,
in the trial you cannot hold a person guilty. Whole trial you have to keep in mind that he is to be proved with adequate evidence. Then till proving he is treated as innocence. But bail is at the initial stage of the case. So as a statutory right, everybody wants for bail. But, but in the object of the act provides that some stringent action has to be taken in view of the materials on record. In your case, even after having good background of two boys, they have indulged to a huge conspiracy, huge accumulation of money in unfair manners. It is an offense against the country itself, not even the society, even the country itself. So sometimes the court has to be more stringent. Some stringent action is required. But now everybody pleaded about this Article 14. Can you justify it another way?
Indeed, Your Lordship. Your Lordships, in the present case, only it is not, as my counsel has mentioned, that the case is not revolving only around Ramta and Ali, but on the UAPA Act as a whole. As he has already mentioned that there have been several cases pending before the court about revolving around, and the under trials have already been sent to jail. Therefore, it is it is a violation of Article 14 and Article 21 of the Constitution, and therefore they have to be given a chance to they have to have a chance to get bail.
Okay, thank you.
Much obliged, Your Lordships.
You are seeking striking down of these provisions. Why not read it down? Theory of reading down. Can it be applicable, or you want these provisions to be struck down? You can take help of the council, number one. There is no problem. You can
Yes,
take
Your
help
Lordship.
of him also. One also can chip in if you want.
Much obliged, Your Lordship.
Read down the provisions rather than strike down. What do you say about it?
Your Lordship, there is a basic difference that continues to exist between the procedure of reading down and striking down. When a provision like this is struck down, it not only clears a provision like this, but it clears possibilities of any further interpretation of that whole law, and no other individual can be prevented from having a proper life and liberty at the hand of this provision. On the other hand, as you have very rightly suggested, your kind selves have very rightly suggested that there is a possibility of reading down, but reading down does not end the provision. There continues to exist, notwithstanding the degree of narrowness or the depth in which the provision would be interpreted, but the provision continues to exist, which could further be exploited to jail and exploit individuals, like it happened in Natasha and recently in Tripura, where two journalists were jailed for things that they possibly never knew was anti-national or could be covered under UAPA. Therefore, your lordships, however, you have very rightly pointed out that it can be read down. The council, to your kind selves, request and pray that it could better be struck down.
Okay,
Much
very
obliged.
well.
Much obliged, your lordship.
Yes, I think then we can hear the next council. But before that, we'll take a short break of 5 minutes before we hear the other side. Okay, you want to make some more submission before we close your... you have to make the relief claim because you want to say something more?
Your Honors,
Anything else you want to submit in terms of your prayer, relief, whatever, anything left for you?
Nothing as such as has been laid in the written submissions. However, the court is requested to address the matter.
Okay, very well. We'll consider
Much
your
obliged,
prayer.
Your Honor.
Yes. So we'll hear the other side. Then they can wait for rebuttal. Petitioner side can wait for rebuttal. So let us hear the other side.
The council requests permission to approach the bench.
Yes, please proceed.
A very good afternoon to everyone. If the respected bench is well versed with the statement of facts, the council would request permission to proceed with the first issue.
Yes, please.
Much obliged, Your Lordships. The first issue deals with whether the writ petition is maintainable or not. It is humbly submitted before this Honorable Court that the present writ petition does not stand maintainable under Article 32 of the Constitution because the instant case involves no substantial basis to render the impugned provisions of the PMLA 2002 and UAPA 1967 to be violative of any of the fundamental rights prescribed under Part 3 of the Constitution of India. The first sub-issue states that the alternatives are not exhausted. The petitioners have approached this Honorable Court under Article 32, and it has been well settled by the Honorable Constitutional Courts that merely because the petitioner has the fundamental right to approach the Honorable Apex Court, it does not mean that the alternatives be ignored. Further, it has been well settled that the Honorable High Courts also have the power to adjudicate upon matters involving the constitutional validity of central acts. This Honorable Court in Union of India versus K.A. Najib has resolved the bail conundrum under Section 43D of the UAPA by holding that the violation of the right to speedy trial forms a ground of constitutional courts to grant bail. Thus, the averments of stringent bail conditions do not render the impugned provision to be violative of any of the fundamental rights. The provisions under the PMLA and UAPA are in compliance with the procedure established by law. That is, the procedure has to be right, just, and fair. Therefore, there is no violation of Article 21. Section 50 of the PMLA is the second sub-issue. Money laundering is a continuing offence with an intense threat to national security. The Honorable Supreme Court in Y.S. Jagan Mohan Reddy versus CBI observed that the economic offences have deep-rooted conspiracies and involve huge loss of public funds and thus need to be viewed seriously and considered as grave offences affecting the economy of the country as a whole and thereby posing serious threat to the financial health of the country. In view of the intricate and deep threat that offences under PMLA cause to national security, it is necessary to understand that violation of the right against self-incrimination under Article 20, Subarticle 3 is attracted only when the accused is compelled to make the statement. The three ingredients to it are accused of an offence, compulsion, and being a witness against oneself. These conditions do not exist in the case of a statement recorded under Section 50 of the PMLA, and as a result, do not violate the same Article 20, Clause 3 of the Constitution. In State of Bombay versus Kati Kalu Oghar, the Honorable Apex Court held that in order to invoke the protection available under Article 20, Clause 3 of the Constitution, it must be shown that the person was compelled to make a statement which was likely to incriminate him. Thus, Article 20, Subarticle 3 does not apply if a person makes a confession without any inducement or threat. Compulsion is an important ingredient under Article 20, Clause 3. However, the objective of the PMLA is to identify the chain that leads to the horrendous act of money laundering. As a result, mere fine imposed for non-compliance with the procedure laid down under Section 50 does not amount to violation of Article 20, Subclause 3. Rather, it acts as a safeguard to ensure the furnishing of necessary information. In Sushil Kumar Sharma versus Union of India, it was held that a court, while examining the constitutional validity of a provision on the ground of possible abuse of the powers, should satisfy that there were sufficient safeguards present. Thus, the writ petition filed by the petitioner stands frivolous, malicious, and must be dismissed for the lack of locus standi. Lastly, to conclude this issue, the Council for the Respondents would like to submit and point out that the petitioners have mentioned in their memorials that this writ petition is also maintainable under this article as a public interest litigation, and the humble contention against the this argument of the petitioners would be that public interest litigation and writ petition are two very different things and two very different routes to approach the Honorable Court, as public interest litigation, as one of its sine qua non, has to be for a public interest and not for any personal gain. In the instant case, the only benefit that the accused will be getting is bail and at the court's discretion, may be the striking down of the provisions of the twin conditions. It does not help the country, the nation at large. It involves no public interest, and even if it involves public interest, the only public interest involved in this case is that of national security and integrity. Now, unless the petitioners want to uphold the national integrity as reasonable restrictions on some fundamental rights of the accused, the petitioner would now like to, the respondent would now like to proceed to the second issue. If the honorable bench has no questions for the respondents, the council would like to proceed to the second issue.
Yes, you proceed first. Yes. You proceed.
Much obliged. Much obliged. The second issue deals with whether Section 50 of the PMLA violates the very basic tenets of the provisions of the Indian Evidence Act. It is humbly submitted before this Honorable Court that the PMLA is a comprehensive statute dealing with these special provisions. It is necessary to build up such special provisions in the interest of national security pertaining to money laundering involving deep-rooted conspiracies. In the instant case, it is well established that the petitioners had been possessing huge chunk of liquid cash, influx of crores of rupees from various shell entities, and operation of illegal trade of weapons through money laundering. In the case of Sheikh Mohiddin versus Section Officer Karnataka, it was held by this Honorable Court that it is a well-settled principle of law. When there is special law and general law, the provisions of special law will prevail over the general law. PMLA is a special legislation whose objective is not merely to detect and punish crimes. The ED's main purpose is to detain property involved in money laundering. PMLA does not give the ED the powers of the police. Section 71 of the PMLA further states that the Act shall have overriding effect and shall prevail over provisions inconsistent to deal with the grave offences under PMLA. The Andhra Pradesh High Court in Dalmia Cements Limited versus Assistant of Enforcement Directorate in this respect observed that since under PMLA investigation there is no provision of forwarding an FIR to the magistrate and the officers investigating the offence under PMLA are not police officers, the protection against testimonial compulsion cannot be claimed under the PMLA. The issuance of summons under Section 50 do not refer to existence of a formal complaint, meaning they are not yet accused. Mere fine imposed does not mean compulsion. The ambit of compulsion has a much wider degree. In the state of Bombay versus Kathikalu Oghad, it was held that it must be necessarily shown that the witness was compelled to make a statement likely to incriminate him. Compulsion is an essential ingredient, but if a person makes a confession without any inducement, threat, or promise, Article 20, Clause 3 does not apply. In order to investigate the sophisticated offences under PMLA, there has to be a special procedure for the same. The powers of the ED are limited, adequate, and constitutional. The prime objective of the Act would be defeated if the procedure under general laws are applied, since it would give the accused time to delete all the incriminating evidence or free from justice, among other factors. Hence, given the gravity and impact of offences underlined under these statutes, it is contended and humbly prayed that the PMLA and UAPA laid down a procedure necessary to deal with the same efficiently to prevent any further harm or damage to national security and integrity. It is hence submitted that the writ petition consequently be dismissed. If the respected bench has no further questions on the above issues stated, the council would now like to call upon the co-council to present the third and fourth issue.
Yes, we have some questions to be asked. Yes.
Council. This section 50 is regarding PMLA is with regard to recording of statements. Recording of statements
Indeed.
of an accused. Now, recently, the Supreme Court has interpreted Section 67 of the Narcotic Drugs and Psychotropic Substances Act 1985. How do you relate this Section 50 of the PMLA Act with Section 67 of the NDPS Act? And the interpretation, do you think that the interpretation that has been given by the Honorable Supreme Court of India while interpreting Section 67 of the NDPS Act will be applicable for interpreting Section 50 of the PMLA Act?
Indeed, Your Lordship, I will definitely answer that question.
Okay.
But I will need
Okay.
Your Lordships to
Okay.
clarify the interpretation given by the Supreme Court.
Yes, very well. Lordship.
See,
Your Lordships, I'm
yes, no, you can consult your other counsel also, no issue. See, statement made under the UAP Act, is it admissible? Statement made under the UAP Act before a police officer, is it admissible? Under the UAP Act, statement made in course of the investigation to a police officer, is it admissible under the UAP Act? UAP Act, because we have referred to UAP Act also. See, statements made by an accused before an police under the UAP Act, is it admissible or not under the Indian Evidence Act?
Indeed, Your Lordship. As long as the statements are made to the police officers under Indian Evidence Act as per Section 25 and 26, then as per the sections of the Indian Evidence Act, they won't be admissible because of the main principle that the confessions or admissions or any sort of statement made to the police officers cannot be treated as a good piece of evidence. It is a weak piece of evidence and it cannot be admissible in court. And further information and further clarification on the UAPA Act and its provisions will be given by my co-counsel, if there's no problem with that.
See, under PMLL Act, they have sought for striking down this provision because it is violative of this Section 25-27 of the Evidence Act, isn't it? Section 50 of the PML Act. The statement made to an investigating officer under the PML Act, it is admissible. Is it admissible?
No, Your Lordship, not under the PMLA. It is admissible under the PMLA as a statement.
But it is not admissible in UAP Act.
Yes, if it's made to a police officer under the UAPA, yes, then it won't be admissible.
So, what is? Can you distinguish this PMLA Act and the UAP Act for the purpose of this classification? Because you see, under the UAP Act, it is not admissible. Any statement made to a police officer or investigating officer under the UAP Act is not admissible. On the other hand, it is admissible under the PMLA Act, isn't it? That's why they are seeking quashing of this. UAP Act deals with terrorists. See, people who attack this country, create terror. In this case, the statement made in course of investigation under the UAP Act to a police officer is not admissible under UAP Act. But it is admissible under the PML Act. Can you explain this? Why this apparent difference between the standard in the admissibility of evidence? In serious cases dealing with terrorists, it is not admissible. But in cases with PML,
the director,
money laundering cases, it is admissible. So don't you think it is more arbitrary, more unreasonable? That why it should not be set aside, why it should not be quashed?
Indeed, Your Lordships, I will answer that. May I proceed to answer?
Yes, please.
Certainly, much obliged, Your Lordship. The PMLA, the Section 50 specifically of the PMLA gives the director or any other person authorized by the director to act as an authority the powers of a civil court, and according to the subsection 2 or if I'm correct 3, the third subsection, the director has requisite powers to take an examination under oath, and that's where the basic difference from my point of contention lies, that an oath is administered to reduce true justice. It is a helping tool for the judicial courts to ascertain the truth. Whereas if a confession or if an admission is made to a police officer in any act or in any case, then the accused will not, the statement made by the confession made by the accused in the police custody to the police officer shall not be admissible under the Indian Evidence Act. The main difference here is that the PMLA gives the powers to the director to examine under an oath, which obliges the person under examination to state the truth, as is very evident under the provisions of the PMLA. And this difference between the confession made to a police officer and the statement given to the director under Section 50 is meant to prove this point. So for the answer, to conclude, I would like to simply submit that the main difference between such procedures is that the confession made to a police officer isn't admissible under the Indian Evidence Act, but certainly if there is an oath administered and the authority has the requisite power under the special legislation to administer that oath and take the examination of the person under that requisite oath, the statements should be admissible, and they are admissible.
Okay. Yes, you may proceed. Yes.
If there are no further questions from the respectable bench, I would like to call upon my co-counsel for the further clarification of current fourth issues. Okay. It was a pleasure arguing for this one.
Yes.
Your Lordship, Counsel Solids to begin.
Yes. Please proceed. Yes, Counsel number 2, please proceed.
Much applied, Your Lordship. Your Lordship, the Council proceeds with the issue number 2 and 4, that is regarding the special twin conditions and the reverse burden of proof. Your Lordship, the Council's contentions are further categorized into three folds regarding the special twin condition, that the provision of the special twin conditions are constitutional in nature and it does not violate Article 14 of the Constitution, as well it does not violate Article 21 of the Constitution. Your Lordship, the conditions are that firstly the public prosecutor should be satisfied and then the court should be satisfied. These conditions, these are read with the section 41 subclause 1 that can be from the pre-amendment in the Nikesh Tarachand case is read as punishable for the term of the imprisonment more than 3 years under the part A of the statute. Your Lordship, the reliance placed by the petitioner on Nikesh Tarachand Shah versus Union of India is intangible in the view of the fact that section 45 has been amended with the amendment of 2018, whereby the word original expression imprisonment for the term of more than 3 years under part A of the statute has been substituted with an expression, no person accused of an offense under this act shall be released on bail on his or her bond. Your Lordship, thus the contention raised by the petitioner with regard to section 45 of the act does not hold good, as the court found that Nikesh Tarachand case that the bill was firstly introduced in which you say that the twin conditions are of the offenses that are committed under this act, but you have connected these conditions with the predicate offenses that are under schedule part A. Now with an amendment of 2018, Your Lordship, this error has been removed. Now the legislature have cured the defect. They have removed the predicate offenses. Now that could be dealt only under other law and confined it to the money launderings only. Thus, Your Lordship, the provision stands revived. For this, Your Lordship, I would draw your attention towards the case that in the state of Karnataka versus Karnataka Pawnbrokers Association, it was held that when the legislatures amend law, the legislature basically corrects the error which have been pointed out in the judicial pronouncements. Resultantly, it amends the law by removing the mistakes committed in the earlier legislatures, in the effect of which it is removed are on the basis of and the foundation of the judgment. And if this is done, the same does not amount to the arbitrariness and statutory overruling, Your Lordship. Your Lordship, coming to my second contention, in the present matter, the petitioners, as the petitioner, my learned friend from the petitioner has stated about the evoke the Article 32 of the Constitution for granting the bail. For this, the respondent counsel would like to submit that they are not entitled to bail because they have a flight risk. Your Lordship, as we well aware of the fact that the nation is facing the problem of economic offenders. fleeing from the country, and they can also tamper with the evidence. It is alleged before the Honorable Court that both the accused fall under the serious gravity of the offense, and it is evident from the finding of their laptops and phones that they have international relations with the right wing and the left wing of the extremist groups. So they have an expertise in the computer technology, and for this, if the bail is granted, they can tamper with the evidences. Your Lordship, the petitioner stated about the gravity. They totally ignored the gravity of the offences. I would like to draw your attention toward the preamble of both the act, that is the PMLA Act and the UAPA Act, at which it states that the reason for its enactment is to avoid the activities, especially related to terrorism and economy, that can harm the sovereignty, integrity, and the unity of the country, and that can't be ignored, Your Lordship. Your Lordship, with the submissions of the petitioner side, they were failed to incorporate the facts in their arguments. For this, Your Lordship, it is humbly submitted that the person who is involved under the anti-social activities and apart from the normal criminality, the accused is also involved in the organized crimes for a different purpose and motive, the crime of a different nature. Upholding the differentiation between the two acts is not arbitrary in nature. Your Lordship, the Supreme Court in the case of the Mendra Kirtpal versus State of UP, that in this case, Your Lordship, the accused was charged with the offences under UP gangsters and anti-social activities, in which the court held that these offenders are altogether belong with a different category, and the legislature has felt that they are to be dealt with a different manner, and accordingly the trial is mandated to be held with the special courts in the expeditious manner. Your Lordship, the petitioner side has raised an issue that these provisions are arbitrary in nature. In regard to this, the respondent counsel would humbly submit that the legislature has classified the offences under section 45 of the PMLA and section 43 of the UAPA, and has provided a separate bail provision on which the bail application of the person of the accused of the offences will be decided. This classification is valid, Your Lordship, and it is based on the intellectual differentia on the basis of the nature of the offence. Since the accused are charged off with the heinous offences, and they are very grave in the nature, they can harm the unity of the state as well. There is a chances of waging a war against the nation, Your Lordship. So differentiating these offenders from the other offenders is not a violative of Article 14 as well Article 21 of the Constitution, Your Lordship. Your Lordship, in the instant matter, there is a rationale behind the extent treatment of the offenders. It is alleged that both the petitioners are charged under Section 3 and Section 4 of the PMLA, along with the serious offences of the UAPA. It forms the continuing offence, Your Lordship, in the case of money laundering, while the initial part of the offence is very quickly. The proceeds of the illegal act can theoretically be utilised over an indefinite period of time. It in this background that releasing the accused on the bail who is charged of committing an offence of a continuing nature falls under the exceptions of the fundamental rights, since it is highly probable that he would attempt to frustrate the case against themselves, especially since the criminal act would still be in progress. Your Lordship, in the case of State of Gujarat versus Mohanlal Gitanjali Prabal, it was held that delicate balance is required is to establish between the safeguarding the personal liberty of the individual and the social interest, and refusal to grant the bail cannot be termed as a denial the rights conferred upon the accused under Article 14 and Article 21 of the Constitution of India. Thus, your Honorable Court should regard the gravity and the seriousness of the offences and regard the reasonable classification of Section 43D of the UAPA and Section 45 of PMLA for denying the bail of the accused. Your Lordship, coming to my the fourth issue, regarding the reversal burden of proof, the counsel humbly submits that the categorized into three folds, that the reverse burden of proof is constitutional nature, and it is not against the presumption of innocence, and it also not violative of Article 21 and the 14 of the Constitution. Your Lordship, my very learned counsel from the petitioner side have raised that the reverse burden of proof is against the presumption of innocence. The respondent counsel council would like to clarify that the presumption of innocence, we all know it is the very fundamental principle of the criminal jurisprudence, which externally enumerates the accused to be presumed innocent until proven guilty. But this fundamental right is underpinned with the maxim semper necessitas probendi incubit ipque, which states that the necessity of prove lies is with the person who levels the charges. As it is also stated in the Honorable Supreme Court in Noor Agha versus State of Punjab by the Supreme Court, the benches were S.B. Sinha and B.C. Sripathar, in which it was stated that the presumption of innocence can't be equated with the fundamental right and the liberty incorporated in Article 24. Further, Your Lordship, for favoring my argument, I would like to this case in which further it was held that while stating the presumption of innocence was recognized to be an element of the personal liberty, Your Lordship, Justice Sinha held that the individual liberty must be subject to the social interest to ensure the security of the nation. And under the provision of Supreme Court, Your Lordship, my learned friend counsel from the petitioner side has stated one case, that was K. Veeraswamy versus Union of India. I would like to request that please go through that case again. The actual decision in this case was that there was a validity of the reverse burden of proof was held, in which it was stated that the burden of proof to the accused to rebut the statutory presumption was held to be just, fair and reasonable, and it does not violate the Contravention Act Article of 21 of the Constitution. In one of the, Your Lordship, in one of the judgment, my learned petitioner side have also quoted about the judgment from the High Court. So I would request that the Supreme Court is not bound to follow the judgments from the High Courts. Your Lordship, while on Your Lordship, Article Section 43D, Subclause 5 of the Act prescribes the reverse burden of proof on the accused. The legislature isn't bound to prescribe the reverse burden of proof. Your Lordship, there are several other provisions also, like NDPA Act, TADA Act, POCSO, even Section 304, Clause B of the IPC have the same provisions related to dowry death. They have the same provisions related to the reverse burden of proof. Your Lordship, there is a very landmark judgment that in the Seema Silk Saris versus Directorate of Enforcement by the Supreme Court, the bench was S.B. Sinha and Singh Patna, in which it was held that the legal provisions does not become unconstitutional only because it provides a reverse burden. The caution as regard the burden proof is procedural in nature, Your Lordship. Coming to my last contention, it is humbly submitted before the court of law. The provisions of reverse burden of proof does not violate the fundamental right. As Your Lordship, the graveness of the offence is an important factor that needs to be kept in mind while denying the bail, whether the right of the speedy trial of the accused stands violated. The offence under Chapter, Your Lordship, under Chapter 4 and 6 of the UAP Act deals with the terrorism and activities identical to it. Terrorism is not petty offences, Your Lordship. It is unethical to the sovereignty, integrity and security of the nation. Your Lordship, it is equally prevalent to refer the case of Kalyan Chandra Sarkar versus Rajesh Ranjan, wherein it was held that the incarnation of the person charged with non-bailable offences during the pendency of the trial cannot be cautioned for the violative of Article 21. As the council have a less time, the most important aspect of the case, the respondent side would like to submit that the petitioner side have very excitingly prescribed about the data they have conducted about the cases. Here, the respondent side would like to present that they try to state a very exciting data, but it can't be dealt with the instant matter because it is the overall data. They have given the example of some protesters, some activists that are being charged under UAP. In the instant matter, the offences is very grave. It is related to the terrorism. It is against the harmness of the integrity, sovereignty, and the unity of the country, Your Lordship. For this, the Lordship, it is true that the burden, reverse burden procedure is a considerably departure from the normal operation of presumption of innocence. But Your Lordship, the reverse burden brings a far greater decrease in the risk of erroneous acquittal also, and is a significant improvement in accepted accuracy overall. Your Lordship, Section 43 E of the UAPA, instated in 2018, is the example of the reverse onerous clause that enacted by the Parliament as a quick fix for the achieving the twin objectives of deterring heinous crimes and increasing the rate of the convictions. Your Lordship, the last contention the respondent counsel would like to submit is in the case of Union of India and A.K. Najib, the court held that there is a reasonable distinguish regarding the provision of reversal burden of proof that held that unless the NDPS, where the competent court needs to be satisfied that the prima facie accused is not guilty and that he is not unlikely to commit the another offense while on bail, there is no such precondition under UAPA. Instead, 43D of the UAPA merely provides another possibility ground for denying the bail on the basis that there is by considering the gravity of the offenses, there is a possibility of the accused tampering with the evidences, influencing the witnesses, and chance of the accused evading by the trial of the offending act. In the present matter, Your Lordship, both the accused falls under the serious gravity of the offences, and there is evidence from the finding of the laptops and the phones and their connections with the international organizations that there is a chance they will do something to harm the investigation, and thus, Your Lordship, the provision, this stringent provisions that are under PMLA and UP can't be held to be violative of Article 14 and 21 of the Constitution. With this, the respondent counsels would rest the case, and may I proceed with the prayer of the case, Your Lordship?
Yes, proceed, yes.
Much obliged, Your Lordship. Whereby it is prayed in the light of issue raised, argument advanced, and authority cited that this honorable court may be pleased uphold the impugned section 45 of the PMLA, section 50 of the PMLA, and 43D subclause 5 of the UAPA to be constitutionally valid, and pass any order, direction, or relief that this honorable court may deem fit in the interest of justice, equity, and good conscience, all of which it is humbly and respectfully submitted. And for this act of kindness, the respondent shall duty bound forever to pray. Thank you, Lordship. It was a pleasure to argue before this honorable court.
Okay, one question. This presumption, the reverse burden, this which has been introduced in this PML as well as UAP Act, when does this reverse burden will start operating? At what stage? At what stage will it be that will the accused be asked to prove that he is an innocent, not a terrorist, the moment FIR is lodged or a charge sheet is filed, or what? At what stage he will be asked to discharge this burden of proof on the basis of reverse burden? Do you have any idea?
Yes, Your Lordship. The way from the point of the when the charge sheet has been filed, the trial has begun. The trial has begun. At that point of time, there it is the onus of the proof that shifts from the prosecution to the accused person.
Therefore, according to you, the moment charge sheet is filed, so the accused will be asked to discharge his burden that I am not terrorist, I am an innocent.
No, Your Lordship, Your Lordship, from the point when the case is presented before the magistrate, then the evidences, when the prima facie case has been made in the court, then there is the onus of proof from the prosecution shifted from to the accused person, that he is liable to prove his innocence.
What do you mean by prima facie proof? In criminal case, the burden is on the prosecution always to prove the case beyond all reasonable, not all, beyond reasonable doubt. Reasonable doubt.
Indeed,
yes. So
indeed, Your Lordship.
So in a case under PML as well as UAP Act, this burden on the prosecution to prove beyond reasonable doubt, till what stage they have to discharge, then the onus will shift to the accused to show that he is innocent.
Indeed, Your Lordship, when the prosecution has proved their case in the criminal proceeding, they have, for example, in the present matter, there are prima facie evidences. They shows the graveness of the offense, and the person is guilty of the offense, that the prosecution has given all the evidences, and the prosecution has proved that there is a prima facie case has been made, then the onus of proof at that point of time shifted to the accused person.
Is it to be do you have any idea called foundational facts? Have you come across this expression, basic facts or foundational facts? When matters relating to reverse burden is considered, in any case, for example, NDPS also, is there under the NDPS Act also, there's a provision of reverse burden. If a certain contraband item is found in the possession of an accused, then it will be presumed that he had possessed that in contravention of the Act. So similarly, under the UAP Act, can you tell us to what extent, if you say prima facie case, then it is not proved beyond reasonable doubt. That will be against the criminal jurisprudence. The burden of proof upon the prosecution always remains. Then when we
Indeed,
say
Your Lordship.
always remains, from what stage that burden of the prosecution will be lifted? It will be replaced by the burden of the accused to prove that he is an innocent. Because if you ask the accused to prove from the very beginning, from stage of filing charge sheet, then the prosecution doesn't have to do anything. No work. You file a charge sheet. The poor innocent man, or whatever he claims to be innocent, he will have to prove. Then it will be very, very arbitrary or very unreasonable to expect an accused to prove himself to be innocent. In that case, maybe it is unconstitutional if you say so. But if you say that, no, the prosecution has still to discharge the burden of proof beyond reasonable doubt up to this. And from this onwards, then the accused has to discharge the burden of innocence. Therefore, it is reasonable. If you say that the accused has to discharge the burden right from the stage of filing of charge sheet, prima facie materials are there, these documents have been gathered, these statements have been recorded, prima facie case, then in that case, the prosecution has to simply sit down and watch the accused to prove himself innocent. In that case, perhaps it has to be struck down. It's being contrary to basic criminal jurisprudence. If you say that no, it need not be struck down, it is reasonable, then what, according to you, would be the stage from where the accused would be expected to prove that he is innocent, so as to bring within the ambit, within the framework, within the parameter of reasonableness, non-arbitrariness? Yes.
The counsel would like to answer your question, Your Lordships. The counsel would like to answer your questions into two contentions. Your
Yes.
Lordship, there are various policy motivations that have been advanced the justification of this burden. For Your Lordship, there is a 47th report of the Law Commission in 1972, which suggests that since the offences relating to the narcotics, for example, as you have stated, the terrorism, and there is full addition that threaten the health and the material welfare of the country, and the special efforts are necessary. Second, Your Lordship, there are practical difficulty encountered by the prosecution in the process of obtaining proof. In the respect, there are within the exclusive and peculiar knowledge with the accused, that only with the help of the accused, with the reversal burden of the proof, that matter can be taken into consideration to prove the guilt of the accused.
Okay. Yes.
Thank you, Your Lordship. It was pleasure arguing before this honorable court.
Now we would like to invite speaker 1 from team TC1 for the rebuttals.
Yes.
The counsel for the petitioner seeks your lordship's permission to proceed with the rebuttals for the rounds.
Yes, proceed.
Much
Please
obliged, your lord. Much obliged, your lordship. Your lordship, there are a lot of things, there are a lot of contentions to rebut. However, the council wants to focus on the first aspect, that is the jurisdiction. Your lordship, in the Harbans Lal versus Sahunia versus another versus Indian Oil Corporation, the Supreme Court unequivocally directed the courts to not always be driven by dirty hands principle, and in case of challenging of violation of laws and violation of fundamental rights, the court should take up in the interest of the larger public. Therefore, the counsels for the respondents don't seem to have considered all the ambit, but the one that helps their case. Furthermore, your lordship, it has been held that there is an element of personal gain. That is the difference between a writ petition and a PIL, that there has to be a personal violation of fundamental right. But is personal gain equal to a vested interest? This was clarified in the case of SP Anand versus HD Devegowda, where the court held there has to be an absence of vested interest and not only presence of personal interest. Your lordship, furthermore, there was reliance placed on Najib's case. Your lordship, it is contested that the Najib's case is based on the Watali judgment, in which the court itself has held that the bench cannot enter into the merits and the demerits of the case while assessing the bail. Therefore, the almost whole of the arbitrary powers lies with the sort of case that is made by the prosecution. Lastly, your lordship, the council wants to present before you 3 examples, that is of Kandan Pahan, because there's been a lot of reliance placed on national security. Your lordship, Kandan Pahan might sound like an unknown name, but that person is a Maoist who killed a lot of people, later surrendered, and now is helping democracy flourish in his region, which still cannot see a peaceful election. Secondly, Darshal Malkan, who is elected a panchayat member from Jammu and Kashmir, and Nambi Narayanan, who spent 50 years of his jail only to be acquitted later. With this, the council submits that not only legal but also humanitarian grounds should be taken by the kind court to assess the instant issue. Much obliged and highly honored to have presented the case for the honorable.
Yes.
Now
The
I
other
would like
side?
to invite
Yes, the other side.
May the respected bench allow the first
Yes.
speaker to rebut
Yes,
the
please. Yes.
petition. I would like to submit my rebuttal only in a few lines, saying that the petitioner has cited some situations which are not directly very relevant to the facts of this case. In the extant case, the very key elements to look at, first of all, are from the point of view of the government, the central government of the Union of India. National sovereignty and fundamental rights, they both are to be kept at a balance. And where there is a question at national sovereignty, national integrity, to the territory of the country, to the economic security of the country, the government has the administrative machinery of the nation has to keep in mind, without violating any fundamental rights and without without doing any harm to those fundamental rights, the machinery has to keep in mind the national sovereignty of the nation as well. And even though the procedure laid down in PMLA and UAPA is just fair and reasonable, not arbitrary, not unreasonable, because sometimes these stringent procedures have to be necessary, because such offenses, the gravity of these offenses cannot permit the machinery to act leniently, and they have to take certain steps, precautionary measures even, to make sure that that all the pieces of evidence are gathered together. The first point is this. And the second point that I would like to come to for my rebuttal would be, lastly, that even though all the cases, all the situations cited by my learned opposing counsel for the petitioner may be true, and they may be very, very real as well, but since the facts of this case, including not to forget the finding of evidence in the form of cash and illegal money that is laundered, and all these evidences almost implicate that the accused have have had these evidences with them, and there was a link established with them and some extremist groups. It cannot be said that prima facie they were allowed to be granted bail, which is why in the competence of the High Court, considering all the factors, the gravity of the offense, among other things, also that if the accused did not get bail, they could flee from justice, and they have also tried to flee from the police officers while the police officers came to their premises once. So to prevent all that, the High Court applied its mind, judicially, its judicial mind, and rightfully rejected the bail. So these are the factors which I would like to present, that the High Court did not grant bail, and that the accused shall stay in custody unless the truth of the whole matter comes out. And the truth can only come out when the due procedure is followed, be it stringent or not. Because stringent or not, it is reasonable and it is necessary to produce the information necessary to come to justice for the courts as well as the machinery. That's all from the submission of the respondent.
Okay, very well. So you had this any query to be okay? Any query? Okay, very well. Thank you very much for we had real pleasure in hearing both the sides. Very keenly contested case, and yes, we'll take a break for our judgment. So I hope all participants also will be there right now. Okay. Okay, then we'll rise and we'll give our verdict soon. Thank you.
Much obliged, Your Lordship.
Thank you, Your Lordship.
Thank you, Your Lordships.
We would like to thank the participants, and it is to inform that the participants will get the link of the valedictory ceremony soon. Thank you, everyone.
Acknowledged.
Thank you.
The participants may leave the meeting.